Sorry about that.
No worries. So for those of you just joining us, you have no idea who I am, and that's fine because who I am is nothing. It's not nearly as important as what I have to say. So we've seen that bipartisan consensus deteriorate almost overnight around the time of the 2020 election. You saw that bipartisan support be replaced by a bipartisan consensus that said big tech is bad and that the law should change. But when you drill down into that bipartisan consensus, the coalition of big tech is bad and the law should change fractures. Because, and fractures badly, the moment you ask, well, how should the law change and why? For critics on the left, the problem is misinformation, disinformation, the spread of conspiracy theories on it. For them, the law doesn't ensure enough content moderation by the big social media platforms. Now, on the right, the complaint is that these platforms engage in too much content moderation. They note that employees and executives are disproportionately left to center, and they're likely to exercise the moderator's privilege in ways that systematically suppress conservative voices, either consciously or subconsciously. So I'm going to talk today about Section 230, right? What the law is, why it's important, and what's driving activists on both sides of the political spectrum who want to dismantle or change it. We'll start by giving just a brief overview. Congress enacted Section 230 at the dawn of the internet age, partly in response to a lawsuit by Stratton Oakmont, the firm owned by Jordan Belfort of Wolf of Wall Street fame. Prodigy was a company that hosted message boards, which is sort of like 90s proto social media platforms. And Prodigy had pitched itself as the family-friendly alternative to CompuServe, which is was more of a no-holds-barred message board system available at the time, because Prodigy, unlike CompuServe, took down offensive material and offered its customers sort of a curated, family-friendly experience. So someone posted a news story on Prodigy alleging that Jordan Belfort may not have been completely above board in all of his trades, right? I know you're all surprised by this. And unsurprisingly, Belfort's response was to great American pastime, and he filed a lawsuit. So he sued for defamation. And he sued not only the person who posted the story, but also Prodigy for hosting the story. His argument was that by failing to take down the news story, Prodigy was liable for defamation, for publishing the defamation and allowing it to be perpetuated. And the court agreed. The court said that for a company like CompuServe, right, someone that hosts everything that anybody puts up, they might be immune from liability for what their users post. But for Prodigy, which is holding itself out as having a right to editorial control, a right to take down user content that it chose not to associate with its brand, then the company should be culpable for whatever information it chose to leave up. Now, Congress thought this was really problematic. Online isn't like offline, Congress realized that when you're talking about creating incentives for companies to moderate, it's a lot harder to moderate at scale when you have millions of online posts than if you have maybe 10 or 15 news stories in the New York Times each day. At the same time, they wanted platforms to have some discretion to be able to take down offensive content. This was a time, sort of the dawn of the internet age. Everybody at the time was worried that the internet might someday become an engine for pornography to be distributed, right? It turns out those concerns were completely farcical. But the Congress at the time wanted to create incentives for companies who are gatekeepers of the internet to keep it clean for kids. And of course, the incentive set up by Prodigy is exactly opposite. If you're saying, I will take down bad material, then you're opening yourself up to a lawsuit for if you're anything that you leave up. If you're general counsel of a Prodigy or a CompuServe, what's the advice you're giving to your clients? Leave everything up, never take anything down. Because if you start taking stuff down selectively, you're opening yourself up to defamation lawsuits, anything you forget to take down. So Congress thought that was a bad incentive structure, and so they passed Section 230 to try to undo the holding in the Prodigy case. So what does Section 230 actually do? There's two key provisions. The first is 230C1. It says no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. All right. What does that mean in plain English? This is basically what you might call posting immunity, right? That this is Professor Casa's famous 26 words that created the internet. What it says is, if you are an online provider, a company that operates on the internet, and you're hosting user content, then you're not liable for what your users say. You're liable for your own speech, but your user's speech can't be attributed to you for litigation purposes. So we call this, or think of this as like posting immunity. You're immune for what your users post. Now the other half, it's a little bit longer. Section 230C2 says that no provider of an interactive computer service shall be held liable for any action voluntarily taken in good faith to restrict access to or availability of material that the provider considers to be obscene, lewd, lascivious, etc. So this you can think of as takedown. If for some reason you as a provider choose to take down a user's content, C2 makes sure that you're not liable for that decision either. So when you read these two together, right, social media companies have almost complete immunity from suit for decisions they're making about either including or excluding user content online. Incidentally, that's why the conservative talking point that you might hear from time to time, you're a publisher, not a platform, and therefore you should be sued or should be liable. That argument fails once you understand how Section 230 works. The rhetoric is supposed to suggest that if you're hosting all user content equally, then you are immune. But once you decide to pick and choose which users you're going to allow and which you're not, then you should be sued, right? That's what the logic of the theory. That's how the law works offline. But Section 230 was designed explicitly to make sure that that's not the way the law works. It's providing immunity for the platform, both for what they choose to leave up and for what they choose to take down. So I think it's important to note, though, that part of the reason why Section 230 is broad is not just what Congress did, but the breadth with which courts interpreted the language of the statute. So a very early case was Zirin versus AOL. This was a case that came out shortly after the Oklahoma City bombing, which you can see in the upper left here, was at the time the most significant terrorist attack ever on US soil. Shortly after the Oklahoma City bombing, some troll, we still to this day don't know who, started posting ads on AOL for really tasteless t-shirts making fun of the bomb. And the ads on the t-shirt said, if you want to buy these t-shirts, call Ken Zirin, and gave his phone number. A DJ on Oklahoma City Talk Radio got a hold of this, read it, told people, call Ken Zirin, tell him what you think of his tasteless shirts. And Zirin was getting harassed, thousands and thousands of messages each week by people in enraged with it. Zirin had no idea this was going on. He didn't know it was posted, he had no idea who it was. All he knew is he just started getting tons and tons of hate. So he called AOL and eventually said, look, this thing is up here, please take it down, right? I'm getting harassed, this crosses a line to defamatory or at least IIED kind of conduct. Please take this material down. And AOL, hemmed and hawed, ultimately decided they didn't want to because they didn't have to. They didn't want to create a precedent where anybody who complains about something online would force AOL to take it down. So Zirin sued. And his argument was that AOL should be responsible despite Section 230. And if you go back to the language here, 230 says that you're not to be treated as a publisher or a speaker, right? So under offline defamation law, we traditionally divide into three different categories: speaker, publisher, and distributor. And Zirin's theory was, maybe we can't, Section 230 says AOL is not the direct speaker of this slanderous material. Maybe it's immune from publisher liability. Publishers tend to be liable at the same level as the initial speaker. But Section 230 doesn't preempt distributor liability. Distributor liability means, we look at this like the difference between liability for the writer of a letter to the editor, the publisher, the New York Times for printing it, or the bookstore, the newsstand that sells it, right? A distributor is liable only if they have actual knowledge of that something is defamatory and they choose to sell it anyway. So Zirin says that Section 230 doesn't preempt distributor liability, that once AOL knew in fact that what was on its site was defamatory to Zirin and was still nonetheless chose not to take it down, he should be liable. But the court said no. The court said that 230 should be interpreted broadly to provide almost complete immunity for anything that a user puts up. So I think with that in mind, right, it's sort of off to the races from there. Zirin set a pretty strong precedent that Section 230 provided significant immunity for social media and other internet-based companies. And I think it's impossible to overstate just how important that statute and that interpretation were to the internet's development. It was the legal framework that was created by Section 230, coupled with technological advancements in storage and broadband speeds that paved the way for the modern social media landscape that we see today, right? Where individual Americans are simultaneously consumers of and producers of content online. Because of Section 230, companies like Facebook and Twitter can establish themselves as platforms where users can easily share content with one another. Because the platform doesn't have to worry about whether the user's speech, what the users are saying to each other, is going to cause some legal liability for the platform as host. If a Facebook user defames somebody, that user can be sued for saying it, but Facebook can't be sued just for hosting. At the same time, though, Facebook can take steps to moderate its own content and take down material that it finds objectionable, right? Stuff like excessively violent or pornographic material, so that Facebook doesn't devolve into a cesspool and without anybody suing them for making that takedown decision either. So Section 230 created the modern internet by making room for these companies to operate. And I mean, not just social media companies, right, like Facebook or Twitter, but comment threads after news stories, Craigslist postings, eBay listings, Etsy posts, just about any company that connects users online and facilitates the exchange of ideas or content is a beneficiary of Section 230. But as the internet has evolved, we began to see some rising concern that maybe these companies should be more responsible for the communication that they're facilitating because of the broader social ramifications of their decisions. And on the left, this focuses primarily on the spread of misinformation and extremism, right? Like that you can take fish tank cleaner to try to save yourself from COVID, or the whatever conspiracy theory du jour is coming out of the servers that are running QAnon. So the critics highlight an important issue. The companies are, as Tim Wu put in, titled his captivating book on the bottom right corner here, the attention merchants, right? They are in the business of selling advertising. So what are they trying to do? They're designing a business model to attract as many eyeballs to their sites as possible and keep those eyeballs there as long as they can. And it turns out that the thing that drives the greatest engagement is extremist content, right? The more extreme or conspiratorial the content, the more likely it is to attract people to the site and make them see it and entice them to stay on it. The downside, right, is that widespread consumption of this kind of material has negative effects on society, and significant effects. So there's a number of Democrats who have introduced a variety of bills to try to get at this problem, which mostly involve exempting misinformation or extremist content from protection under Section 230. So in other words, you'd still have protection for hosting user content, except for content that's spreading misinformation, or except for content that's extremist in nature. Some other permutations of this theme is liability for algorithmic amplification of extreme content, which is something that a shade of that argument is something the Supreme Court is considering right now in the Gonzalez v. Google decision. So on the right, the concern isn't not that companies are engaged in not enough moderation. They're saying companies are engaged in too much moderation. They're focused on the fact that the private gatekeepers to access to social media are disproportionately left of center, which is a problem if they exploit that power in ways that disproportionately censor right of center content. Particularly if, as the Supreme Court tells us in Packingham, social media is becoming the modern public square. Now, I'll say as a preface, it's not clear to me how much viewpoint-based discrimination is actually happening in practice. There are some preliminary academic studies that have been trying to kind of get at this problem, and what they've suggested, at least thus far, we don't see a lot of systemic bias in against conservative viewpoints. And if you look at sort of the top 10 list of what's trending on Facebook or on Twitter each day, right-leaning commentators like Ben Shapiro and the Daily Wire stuff tend to be within that mix. On the other hand, right, anecdotal high-profile moderation missteps, such as the attempt to block the Hunter Biden laptop story, certainly reinforce the conservative grievance narrative. And I think more generally, in today's hyper-politicized environment, one can understand why this rhetoric appeals to conservatives. Social media is one of our most volatile battlegrounds. And it's where emotions run high, and it's where platform-based restrictions on one's advocacy can really feel like a personal slight. And of course, any gatekeeper's decision about moderation is going to be informed by that gatekeeper's priors. Now, at least on some subconscious level. That's the lesson behind the 2012 Stanford Law Review article called "They Saw a Protest," where different people were watching video footage of a political protest, and they reacted differently about the protest, depending on whether they classified themselves as right or left, and whether they were told that it was a protest of abortion outside an abortion clinic versus a protest of the don't ask, don't tell policy outside of a military recruiting. Same imagery, but the way you classify the protesters and the response to the protesters vary depending on what your political views were and what you thought the political views of the protesters. So the article talks about the importance of what we call cultural cognition, which the article defined as the unconscious influence of your group commitments on the perceptions of legally consequential facts. Or in other words, intentionally or unintentionally, right, we're all likely to have some bias at the margin about whether to suppress controversial content based on your own priors, right, the gatekeeper's priors. And so if we think that's probably the case, and there is an effect at the margin, then it makes a difference that the vast majority of the employees, and particularly the executives at social media companies, lean left. That's the concern that led Florida and Texas to adopt statutes requiring some form of common carriage on social media platforms, which preclude them in some ways from engaging in viewpoint-based discrimination against speakers or content. And these two cases have generated a circuit split, which I also expect are going to be before the Supreme Court fairly soon. Now, I think there's a number of First Amendment issues with both of these proposals to regulate misinformation and proposals to require common carriage. And Professor Manahan can talk a little bit about that. But setting those First Amendment issues aside, it seems to me that asking government to either regulate misinformation or to compel private actors to carry speech with which they disagree are both bad policy. So in addition to facilitating user speech at mass scale, I think it's important to note that Section 230 promotes competition and innovation among platforms. Immunizing platforms from liability for their users' content means relieving them of the costs of moderating that content and the risks of lawsuits by virtue of doing so. And so that significantly reduces the barriers to competition that we see in the online marketplace. And that's what allows new startups to come in and challenge entrenched incumbents, right? It's why companies can so easily test new and different business models, and why you see so much dynamic competition in the online space. The history of the internet is the history of what we call Schumpeterian creative destruction, right? AOL rises and then gets displaced by Yahoo, which gets displaced by MySpace, which gets displaced by Facebook. And 5 years ago, we all thought Facebook was super dominant, and guess what? TikTok is sort of the new thing. The government's trying to crush that. Have fun with that. So the history of the internet is the history of disruptive competition, often from upstart companies and often from unexpected directions with new and better ways to connect consumers and to curate content. My strong sense is that we tinker with this environment at our peril. Section 230 is woven into the fabric of online society, And it makes it very difficult to predict how change to the statute would ripple through that internet ecosystem. Without Section 230's protections, it would be more difficult for a disruptive entrant to come and challenge the big tech titans. And indeed, I think it would be really ironic if, in the interest of cracking down on big tech, Congress made a decision that actually made it harder for new companies to challenge the existing big tech giants. The one time Congress did try to edit Section 230 to promote a policy goal was in 2017 with FOSTA. FOSTA ostensibly exempted from Section 230 protections certain posts about sex trafficking, right? And the idea here was to eliminate immunity for certain claims that were related to prostitution and sex work, so that social media platforms would be more interested in preventing sex trafficking online. The studies that have come out about the effects of FOSTA in practice suggest that, in fact, it had the opposite. That it did drive sex trafficking offline, but it didn't reduce the total amount of sex trafficking. It just made it harder to see. So police officers who could easily monitor online postings and use that to try to rescue trafficking victims. It makes their jobs harder post FOSTA because now those interactions are occurring in less transparent offline environment, which makes the working conditions of traffic victims more dangerous. And at the same time, it has a chilling effect on free speech as people are concerned, or platforms are concerned that some user speech may get close to the FOSTA line and take it down as a result. My fear is that deleting or modifying Section 230 protections for misinformation might have a similar problem. So who decides what counts as misinformation? At the height of the pandemic, proponents of the lab leak hypothesis were derided for engaging in conspiracy mongering. But now the government suggests that it's at least a likely explanation for how COVID was unleashed on the world. It's generally, I think, a very bad idea for the government to decide what is and what is not the truth. And if you doubt me, ask Galileo how that went for him. In the Structure of Scientific Revolutions, Thomas Kuhn uses the shift from a geocentric model of the world to a heliocentric model of the solar system to explain how scientific knowledge advances over time. You have a dominant theory, dissenters find holes in that theory and kind of pick away at it over time. And eventually, if those dissenters become more convincing to people, then the scientific consensus shifts. That's how learning happens. It's how the knowledge in society evolves. Kuhn tells a great story using Copernicus and Galileo and the shift away from Aristotelian mechanics to walk through that cycle in particular. But that model breaks down if the purveyors of the dominant paradigm can prevent those dissenters from ever challenging the status quo. So in other words, conspiracy theories are the price that we pay for continuing to test what is true and advancing human knowledge. And to use the government as a cudgel to decide what is or is not misinformation risks disrupting this cycle. Similarly, I think that the proposals on the right to require common carriage obligations on social media platforms also have deleterious consequences. If platforms can't remove content with which they disagree, then it becomes harder for platforms to compete against one another. The way that platforms compete for users is by having different content moderation schemes, right? Facebook doesn't allow violent content. They don't allow pornographic content. Twitter allows that content, but puts it behind a shield, right? So you have to click through, you get the warning. In 8chan, it's like just a free-for-all. Everything goes and nothing ever gets moderated. Moderation allows for that differentiation among platforms. And that's important both because the world is not homogeneous, and so different people have different tastes. So allowing different beneficial. But I also think that that's what makes the internet more efficient, right? In a pre-internet era, the biggest challenge to learning was information, right? To learn something, you had to go to a library, get a book. The book wasn't there, you had to go to a different library. Finding information was, trust me, I know, I wrote all of my high school term papers in pre-internet era, right? Finding information was a really hard battle. The genius of the internet is that it reduces information cost to almost zero. Everything you can possibly want is available from, to be transmitted around the world at the speed of light for virtually zero cost. We are awash in information. The internet has reduced information cost to zero, and that's fantastic. The downside to that is we have an increase in filtering costs, right? Needing to separate the wheat from the chaff to figure out among this like plethora of information, where is the information I really want to know? Content moderation, algorithmic separation of user content, individualized news feeds. These are all ways that companies compete to reduce those filtering costs. Like when Facebook presents to you its feed, that's its sense of how to filter the fire hose of content on the internet for just what you want. We want companies to compete with one another to find new and better ways to filter. And a law that says you can't filter, you have to host all viewpoints or all content, flattens that competitive landscape and makes it so that all of these companies are more or less the same. I'll close with Elon Musk's message that in retrospect, it was inevitable, right? The competition among these platforms leads to not only a better internet ecosystem, but a more stratified system that serves more strata in society, rather than reducing us all to sort of a one-size-fits-all model. And my strong sense is that Section 230 should be protected in order to reinforce that competitive dynamic, not modified in ways that squelch it.
Thank you. So now we have Professor Manahan. He is a law professor here at Cornell, and he is a retired judge of the Superior Court of New Jersey Appellate Division. Prior to his appointment as a judge, he was the prosecutor of Union County, New Jersey. He was also an assistant attorney general and director of the Office of State Police Affairs. And he was also in private practice, where he was a partner in the New York law firm Stutterly Stevens, and in New Jersey law firm Burry and Manahan. He was appointed to the bench in 2003 and initially served in the law division, where he was assigned to the civil, criminal, and family parts. He was the criminal and civil presiding judge, the chair of the Conference of Criminal Presiding Judges, a member of the Judicial Council, and co-chair of the Bail Subcommittee, which recommended reforms to the New Jersey's bail system, and that was ultimately enacted into law. In 2014, he was elevated by Chief Justice to the Appellate Division, where he authored over 400 opinions, both published and unpublished, and he later retired in 2018. Well, that's welcome.
I feel humbled after, not necessarily that introduction, but humbled listening to the introduction of Dean Lyons. He is truly an expert in internet law. And I'm here this evening to demonstrate that even someone who's relatively new to it can learn and can pick up on it. But thank you, Dean Lyons, for you more than set the table. But I'm going to spring off of Dean Lyons' final points. Obviously, the Dean is a proponent of the continuation of Section 230 and the protections that it provides. I'm going to talk this evening about two cases pending before the Supreme Court of the United States, some of which you might be familiar with them. Gonzalez versus Google, and Twitter versus Conda. If you're not, hopefully at the end of my talk this evening, you'll be very familiar with them. But I dare say that if you want to learn more about these two cases, I invite you to use search engines. And you will become much more intelligent on these two cases. I mentioned to George and Maria tonight outside that not only had I developed an overly large folder on these two cases, but I had watched podcasts and just to obtain various points of view on these two cases. So what are these two cases? Well, right before I get to that, I want to talk very briefly about the interplay, if any, between First Amendment rights and what we're talking about in terms of the case in Florida and the case in Texas. First of all, we must never confuse two, even though free speech and the First Amendment are synonymous. The First Amendment and free speech do not always mean that any time someone censors or moderates someone's speech that is actionable, because it is not governmental action. These are private enterprises. All right, I just want to make that point quickly. I'm not going to belabor it. That has nothing to do with the issues in Gonzalez or in Twitter versus Trump. Among the readings, the information that I read, the articles that I read were things such as the future of the internet is in the hands of SCOTUS. These decisions will be the most significant decisions in the history of the internet. The internet is in great danger. Of course, wasn't that very frightening? We all rely on the internet. I do, you do, Dean Lyons does, we all do. So if this is going to be the result of these decisions, we should all be very fearful. What are we going to do? The end of the internet. So if there were 26 words that created the internet, I guess Gonzalez and Twitter are going to be the 10,000 or 20,000 words that end it. I don't think so. I don't think so. Section 230 has been referred to by some scholars as the Magna Carta of the internet. Wow, that's a pretty impressive statement. Magna Carta. Some refer to it as the equivalent of the United States Constitution in terms of the internet, the founding document. Well, why is it in jeopardy? And what is it about these cases that could place it in jeopardy? What is it about the issues that could place it in jeopardy? Well, these two cases share a common thread, but yet they're distinct and different. What do I mean by that? Tragically, the common thread that they have are terroristic acts that resulted in the death of many individuals, but two individuals involved in this case. One was in Paris in 2015, when Naomi Gonzalez was sitting with friends at a cafe, and she and her friends were murdered by an ISIS terrorist. 2 years later, almost 2 years later, in 2017 in Istanbul, Turkey, while in a nightclub, Naras Alassa, a Jordanian citizen, was murdered along with 29 other people by an ISIS terrorist. That is the factual common thread of these two cases. But how are they different? And I hope to explain it in such a way for those of you who are not familiar with these two cases, you can understand the difference. Gonzalez versus Google deals with whether or not Google, YouTube, should be afforded immunity under Section 230 because of its conduct. And its conduct was through recommendations of particular sites. They didn't sponsor it, they didn't put it up in the sense that they were the author of it. But the argument is they were more than just hosts in doing this. And what sites did they recommend. Sites that were punitively. Sites that would cause someone to want to be a member of ISIS. They were recruiting sites. Now, I don't need a show of hands because I know I get a unanimous show of hands as to who uses YouTube. There you go. So you raised your hands anyway. Didn't need much incentive. So you raised the hand. I directed you to that, by the way. So you use YouTube. And when you use YouTube, you picked up on, and yes, you have, that all of a sudden you start using the right side, a panel of other sites that are related. I don't care if you're listening to music, your whatever genre you're in, YouTube starts putting up their thumbnails. And they're so good, the algorithm is so good that it becomes personal to you. Not just anybody that likes to listen to Neil Young, I'm dating myself, but if you listen to that, you'll get a lot of Neil Young like music, okay? But it's be personal to me. That's how sophisticated it is. And the question in the Google case is, does this type of conduct, is this use of this algorithm to target or to recommend these thumbnail sites, does that remove the immunity? They go beyond the host. They're moving more toward a publisher. I don't have to talk about the Zeran versus AOL case because Dean Lyons covered that, but if you're interested in this area of law, you should read that. And why should you read that beyond the facts as Dean Lyons articulated them and as he showed them in the slides? Why should you read that? Because it has been followed over 350 times in cases. It is the case, one would call it the seminal case, that expanded the immunity under Section 230. So, I mean, the Zeran case, again, I invite you to read. Background on that is, in addition to what Dean Lyons pointed out, was horrific. Not horrific as in murders that we're talking about in Gonzalez and the Twitter case, but horrific in the sense of Mr. Zeran, a totally innocent person, was driven out of business, literally, by being trolled. And AOL, as Dean Lyons pointed out, knew it. They were put on notice, and yet still allowed it to take place and were considered immune. What Gonzalez, first of all, I know whether you're taking an internet law course or not, or anything related to it, there is a course that you've all taken, even if you're a 1L, it's called torts. Who has not taken torts? No one. Okay, good. What both of you are not. You don't remember. There's a difference between not taking it and not remembering.
That's okay, I don't remember either, it was last year.
Okay. Well, I'm going to talk about a case now, called Paul's Graph in a moment, which Dean Lyons and I remember vaguely from years ago in the dark ages. There still was a Paul's Graph case, but these are what we've now developed in this era to be cyber torts. Okay, you understand what we mean by that, but they still have the tort principles, and these two cases deal with cyber torts. Talking again about commonality. But let's take it one at a time. In Gonzalez, the question becomes whether or not Google, YouTube, lost its immunity, or should lose its immunity, because of its conduct. Well, how active has this case been in terms of its prominence? Usually, a case that gets to the Supreme Court, has to be fairly prominent. You may not know all cases on their docket, some are more prominent than others, obviously, but it has to have some import. Either jurisprudentially or public, whatever it is, it has some import. And many times, there are amicus briefs that are filed. In fact, very often, by a case that goes to the Supreme Court. Not all, but many times. There are 78 amicus briefs that have been filed from Gonzalez, 78. Over 500,000 words of amicus briefs have been filed. This is a big case. This is really important. Well, I'm going to espouse a theory, not a result, because I don't propose to know what the Supreme Court is going to do, but I'm going to espouse a theory about Gonzalez and Twitter. Rather than the Supreme Court altering the internet, rather than the Supreme Court making a decision, rendering a decision that will eviscerate Section 230 and have this calamitous effect. Or rather than the Supreme Court issuing a decision that puts these internet providers finally in their place, teaches them the lesson that they've so long deserved to be taught. Supreme Court, I suggest, has the opportunity to duck the decision. When have they ever done that? Oh, many times. Well, how can they duck this decision? There are 78 amicus briefs. How disappointing would that be for them to do it? Both cases, I said there's a commonality and there's a distinction. The commonality is that it deals with terrorist activities. So I'm going to switch a little bit and go quickly to Twitter. Because Twitter is not a Section 230 case. Oh, wait, wasn't this a talk about Section 230? What are we doing here? What are you talking about? Twitter? It's not, well, it has Section 230 impact. Certainly does. But it is not as pleaded a Section 230 case. It's a cyber tort that says that because Twitter allows terrorists like ISIS to post their site, they should be responsible for the outcome. Under a law that has nothing to do necessarily or directly with 230. That law deals with the Anti-Terrorist Act, anti-terrorist activities. The claim is that Twitter, by just allowing this to happen, has aided and abetted, under this act, terrorism, and should be responsible for the result. Postgraph, proximate cause. First of all, one thing you probably learned in your tort classes: are you responsible for the intentional or criminal conduct of another over whom you have no control and over which there is no agency? Anyone believe that that's? You don't have to take course 4 years ago. Yeah, that's pretty much our understanding, right? But under the theory of the case, Twitter, not encouraging, not soliciting, not participating directly, but allowing, in a passive way, allowing this type of activity has aided and abetted. During oral argument, the justices were all over the place in terms of their questioning dealing with aid and abetting. What constitutes aid and abetting? Basically, what it comes down to, so here's my point I'm making as to why they're related and why the Supreme Court could actually duck this once. If in Twitter, decides Twitter first, and decides that there's been no violation of the Anti-Terrorist Act, to be specific, it's known as JASTA, the Justice Against Sponsors of Terrorism Act, which provided a civil remedy. If there's been no violation, no proof, aiding and abetting under that statute, that case is over. So is Google. Then they don't have to decide section 230. Okay. Now, I said I'm not a prognosticator. That's just a theory. It may go that way, it may not go that way. They may, this court may decide that Google is liable, that they're not immunized by virtue of their conduct, their specific conduct of targeting or recommending, that they're not. But then again, they don't have to do that. They may not have to do it. They can avoid it if they choose to decide the case that way. So conversely, if they decide Gonzalez, say, yes, this type of targeting activity, this type of recommendation, procedure 2, is not immunized, that Google could be liable, the case could go back and heard on its merits as to whether or not there was then a violation decided between them. And it would come under FASTA. So you see how one could control the other, which means, in essence, if they believe there's still a viable course of action, then under Twitter is found, I'd have to find, yes, there is a viable course of action. By the way, you all took civil procedure too, right? Think federal, Civ Pro, nobody calls it civil procedure, Civ Pro. I won't talk about Civil versus Wilson, I promise you, but the bottom line is that you then know what Rule 12b-6 is. Professor, we didn't come to this lecture to be listen, okay? Failure to state a claim upon which relief can be granted. Okay. You heard that a few times, maybe. It is the knockout punch in litigation. It's the first blow, it's the first round, and you just knocked out your opponent if you win that. No discovery, doesn't go any further. You don't even have to answer, except to argue that under 12b-6. Okay? There's an analog in almost every state or two. So you can argue that. That's what happened in Twitter case. All right. So where are these cases going to go in terms of section 230? I most certainly could be inaccurate in my prognostication. They certainly could go another way. There are certainly a whole host of ways that the court could decide these issues. But what happens? What might happen? Prognostication. What might happen if the Supreme Court decides that there is a cause of action in Gonzalez? Will it be the undoing of the internet as we know it? What impact will that have on free speech over the internet? What conduct will the providers then engage in or have to engage in to protect themselves from liability? Will it be the end of the internet as we know it or not? Actually, Dean Lyons made a very good point among many in his talk, and one of them was, when Congress and even the courts consider action on these immunities, you forget about how the internet actually grew. I talked about it. It wasn't just Facebook didn't spring out of air, out of nothing. These companies didn't become worth billions of dollars out of nothing. They had to grow from a small seed to get there. If you're going to remove immunity, you can kill off the competition. You kill off the small companies. It will have a very adverse effect. Some companies where employees will be able to take the punch. Others won't. They'll dry up and go away. Who believes in free speech? Anyone raise their hand? Well, some don't, that's good. I don't. But we of course that. Of course we do. Lyons pointed out, and why he's a proponent of the protection, and so am I, is that the problem with immunities, and it's been cited oftentimes, it's stated oftentimes in cases. The problem with immunities is that it protects bad conduct as well as good conduct. On the whole, it is more beneficial than none at all. I don't have a rooting interest in the outcome of Twitter versus Tamna, nor of Gonzalez versus Google, except please don't take my search engine away. I mean, how I construct my courses, how I do my research. Please don't do that to me. And let me make one final point, distinction. Is there also a fine line distinction between the type of search that one would do, Bing search, Google search, I'll just use those two search engines to be prime. And when you do, let's back up. When we do those type of searches, we expect results, but not only do we expect results, but we expect results that are what? Responsive. We want response, because if we don't, we'll go to another search engine. We don't want to go to page 6 to find an article or something that we're really looking for. We don't need to do it. And so algorithms are used to try to find the most responsive search. If you go back again and search again, you'll see a different ordering of them. Gee, what a surprise. Because again, the algorithms at work. Anybody have a problem with that? But if you're doing perhaps a different type of search, and there's an ordering to it, should that be actionable? One not be actionable? One be actionable? And who's to say? Who's to say which one should be actionable, which one cannot? In effect, isn't the algorithm operating in the same fashion? It's just so if you want to read the numerous articles that are out there on Twitter and Tumblr, you can, if you really want to get into it, you could read all the amicus briefs. But I don't think any of you have time doing what you're doing for that. But what would you have to do in order to do that? If you had the time, you know, if you had the inclination, what would you have to do? Order the briefs, you know, try to get the hard copies. No, we look at them online, we try to read them online, we try to get information online. So the internet is so valuable, so important, that even though it's not 1996 anymore, that we can state with certainty, even in 2023, we have to jealously guard the internet and protect it, even when that immunity detects bad conduct. Thank you very much.
Thank you so much. Now we will take questions if anybody has any.
Sure. So, thank you very much for the wonderful speech, the Lyons and Manahan. So, I have actually two questions. The first one is directly related to Section 230. The second one is not, but is regarding the government's possible intervention in terms of censorship. So, my first question is, we have seen some very interesting legal transplant, Section 230, in many other countries. So it also has some post-transplant development to 230 that's very different from how it works in the United States. So one of the possible post-transplant development was to provide in addition to the notice and deletion clause, but provide a counter notice and recover clause. So basically, following the notice and the deletion procedure, if the other party whose content has been taken down and showed evidence and proving their innocence, then the internet service provider will be able to forward these evidences to the other side. And if there's no litigation, or if there's no formal judicial proceeding or administrative proceeding from the original side, then the ISP has to or are required to recover the original content that has been taken down. So I'm very curious about your view on whether this is going to be a good idea if this is implemented in the United States. So my second question is about the influence of internet referral units that has already been adopted in the UK, in Israel, and in France, and the European Union. So basically, and also in the United States. So according to The Guardian in 2016, there has been a leaked document from the White House agenda, which says that the White House was trying to consider to have more ways to identify terrorist contents online, so that online service provider will be able to remove it if it violates the term of services. And also consider whether it's possible to have similar kinds of internet referral units from the government. So what is internet referral units? It's basically a governmental unit that submits non-binding requests to private firms, for example, YouTube, from their platform, so that the possible violation of platform-owned term services will be the legal basis to remove the content. So I wonder, in addition to Section 230, do you think this is going to be a good idea in the US to have this kind of approach from the, for example, the federal government? Thank you so much.
Sure, so on the notice and comment question, or notice and takedown provision issue, this is the way that IP complaints happen, right? So one of the things that's exempt from Section 230 defense is copyright and trademark claims. If YouTube is hosting something that violates copyright, they can't rely on Section 230. Instead, it's covered by Section 512 of the DMCA, which basically says if the copyright owner complains about it, you take it down, and if the user says no, it's fair use or whatever, then you put it back up. That works to some extent. There's a number of critiques of this model because the amount of traffic that it generates is tremendous, right? Google takes in millions and millions of takedown requests every day, and they're mostly automated. And what you find is that the owners of copyright protection have more money to send takedown notices than individual users have to put them to lawyer up in order to fight and put back notice. And so there's a resource asymmetry, which gives the complainant a heckler's veto. If I say, hey, this violates copyright, Google's just going to take it down. And they're going to take down a lot more than they're going to put back. And so over time, that tilts in favor of the copyright. If you magnify that beyond copyright to defamation claims and product liability, and the rest of the claims that encompass the world of tort, you basically end up with money driving the process rather than ideas. I'm concerned about the way that gets distorted. I think in theory it works really well. In practice, our sense with our experiment with IP suggests that it's not. It's kind of suboptimal. On the government reaching out to suppress content, this is I don't know a ton about this. I'll say the IFUs, but I will say that. The same mechanics that you describe are exactly what Elon Musk is trying to expose with regard to the Twitter files, except it's not exposing terrorist content, it's exposing anti-presidential content, right? Political content the government disagrees with. And I'm always worried that the path from government to private moderator ultimately winds up with the government co-opting the moderator in ways that we would find offensive in the First Amendment. Other countries aren't as uncomfortable with that because many other countries do not have as robust First Amendment protections as the Europeans tend to think we're kind of crazy in the way we protect, for example, hate speech. And our sense, as I think was Manahan noted earlier, was a lot of bad stuff gets through, but that's important to protect the good stuff, and that's where we as a society.
I don't have anything to add. Professor Lyons is more expert certainly in this area, but I will point out that whatever occurs with these two cases that I discussed this evening, there already are, as you point out, international differences between how countries deal with these internet providers as opposed to the United States. So if you assume that Meta still wants to operate in the European Union theater, it's going to have to make changes and will make the changes. It might not be a bad test tube for what might come to this country, but we'll see. And again, it's international, and it's going to be affected by the laws, the local laws.
Yeah, so I guess going to Gonzalez and Twitter. Google won, I believe, in the court below, and Twitter lost. And I know they're not the same case, but do you think there's a workable way where Twitter kind of loses again, Google kind of wins again? So we're still at section 230, but we're kind of addressing the terrorism issues. And we're not like getting rid of section 230 or anything, but we're saying, you know, there are protections against terrorism and stuff like that. Or do you think we kind of need to see both cases go for Google and Twitter for the standard to be work long term?
I do not. I think that sometimes when we look at these cases, we look at them as they're very highly complicated. These again are cyber tort cases. One is focused more on an immunity if in fact there is a cyber tort. The other is there a cyber tort? Then thereafter might there be immunity. So I think they have to be decided, if that's your question, I think they have to be decided together. As the Supreme Court has decided to hear them together, even though, as I hypothesized, there could be a way out without having to deal with internet. There's one other aspect of this too, and I don't mean to make it sound like that the justices sit in conference and say, "Oh, how can we get around this? Or how can we figure this out so we don't really have to make a decision?" Or they could turn to Congress. They could leave it to Congress to decide whether or not there should be any amendment. I know that Justice Kagan made an offhanded comment during oral argument in Gonzalez said that they were so intertwined, it was sometimes difficult to figure out which case they were talking about because they have same claims. But in any event, he made a comment about, we're not experts, we're just older people, maybe we shouldn't be doing it. So there could be, and Dean Lyons testified before Congress, he's done on a couple of occasions, and when they talk about some modifications, amendments, laws, things like that, changes. The court could also, these both cases, say, we're gonna pass this along. I think they have to decide, Twitter, is this aiding and abetting? Right? They have to grapple with the FAST statute and decide, are they going to interpret it narrowly, saying this is what aiding and abetting is, this is what it isn't, this isn't, or they're going to look more broadly and say this certainly could be, and now we're going to send it back and let it play out.
Yeah,
Go ahead.
I think that's right.
No.
And I think that's right. I think that the court has to decide the Tomlin case, because if posting terrorist content doesn't violate the anti-terrorism statute, then it moots the question of whether 230 is a defense to that. The difficult question is if it really loses and the court finds that it does state a cause of action, because once that case is remanded, the first thing the court is going to say is, okay, then section 230 is not defense, right? So the court has to at that point decide themselves. I think you're right that that's the way the court's going to go, and part of the reason why I think that is because I've watched a lot of Supreme Court arguments in my time. I have never seen an advocate do more damage to his client than Gonzalez's counsel did in Gonzalez v. Legal. It was horrible, and there's reasons that I can talk about why I think it happened the way it did, but it was very clear over the course of the argument that this court that was confused as to what was going on in the case, the counsel did not help. And if they can't moot the case, then I think there's a good chance that they will dismiss it as improperly granted, because these are not the facts that Justice Thomas was looking for to try to get the Supreme Court to make a statement on section 230.
If I may, that's a great point. If you remember the malware advice from, I think it was October 2020, and it's petition cert was denied. But this board in particular has developed this practice where even when there's a denial, one or more of those individuals who don't agree with that decision of justices weigh in and issue a writing. And Justice Thompson, well, this was not, I think this was not the section C1, I think it was a C2. I think it was, in that case, it was a little different, but clearly Justice Thomas made his point clear. These are private companies, these are billion-dollar companies. We should be paying attention to these cases. We're looking for a case. So the court watchers believe that Thomas was probably among those who granted a petition for cert here and wants to address it, wants to be.
So at least for Gonzalez during the oral argument, a lot of the, like I know Thomas and I think some of the other justices, they really paid attention to YouTube's homepage. Like the for you section, right, where they would show these videos of recommendations. But it seems like they are leaning towards that this homepage is what we as YouTube recommend for you. And so it's the interests of the user, but in a way it could also be the interests of what YouTube think is right. And so I think, you know, for example, you could be big as vaccine denier, but I think you won't see a long form vaccine denying video on the front page of your YouTube. And so where do you think, and this is for both, where do you think we can draw that line? Because it seems like, I think the majority of the justices, at least for Gonzalez, are going to say, this isn't just like a library where you can just get whatever you want. This is more of very narrow newsstand, where yeah, we're going to show things that you like, but if we don't like it, it's not going to be there.
Yeah, so it's a clever claim, and that's why I think the court originally was interested in Gonzalez, right? Because the line that 230 draws is YouTube's not responsible for its users' speech, but it is responsible for its own speech, right? So Gonzalez's theory is, I'm not suing you for hosting ISIS content. I understand that that's, you know, 230. I'm not suing you for being ISIS's publisher. I'm suing you for being ISIS's recruiter, right? What YouTube did was, you have a profile on me, and based on your profile, you think that I am susceptible to extremist content. And you said, hey, Lyons, you in particular would like to see this video. That Gonzalez's theory is, that's YouTube's own speech. When they say you should watch this video and not that one, that's YouTube's own speech and should be exempt. I think that has some intuitive appeal. The reason why I think it fails, ultimately, is that every recommendation that every search engine is making, every social media timeline is making, is in a sense an algorithmic organization of data. Every time Twitter gives you a news feed, that's Twitter saying you should look at this content and not everything else in the Twitter firehouse. If anytime they're making a recommendation to you, this is the content you should see, then it becomes the exception that swallows up the rule. That every decision that any social media company is making is an algorithmic statement and not, and that eliminates the whole theory of 230, which is that you shouldn't be liable as the publisher of someone else's content. So I think it's a clever theory, but I think when you start to unravel it, what it winds up doing is eliminating 230 completely. And I don't know, of course.
I can't improve on that answer.
Yeah, you were mentioning the definition of our bias, and I think there have been a series of these kinds of defense by you mentioned Tyson, also just as well search during these defense. On the other hand, you also have just Cornell, who the fields voted for voted against net neutrality with regard to editorial control. So I was wondering if you have any opinion or any idea on whether the Supreme Court might be likely, when facing these kind of issues, they eventually probably have to create some kind of First Amendment extension and obligation towards private parties, which, as my understanding is, would be really atypical to the American constitutional law, and what this might imply in general for the constitutional landscape.
So I have a different permutation of this talk, which focuses on. I think a year ago, I would have said, and then I think this is the question that's going to be presented by the Texas and Florida cases when they come up, and they're going to come up soon. A year ago, I would have said, First Amendment protects social media right to decide what speech they want on the platform and whatnot, and it's not even close. Maybe you get Justice Thomas, but it's going to be 8-1. I think the First Amendment landscape is not nearly as solid now as it was last year, given what Alito and Gorsuch and Thomas have said in response to the Texas case. There is a theory under which, and so this is one of the first I was making earlier, that the First Amendment only applies to state entities. Historically, we've not thought it applies to private entities, except with regard to some experimentations the court engaged in where companies acting like the government. So Marshby, Alabama, the company-owned town scenario, if you walk, talk, and look like a city, then you're going to be bound by the First Amendment, even though you're not actually like an arm of the state, you're in fact owned by a corporation, you're still bound by the First Amendment. In the 60s, that was the 36. In the 60s, we extended that briefly to shopping malls on the theory that, and some of you may have gone over this in your property classes, right? That shopping malls were replacing the old downtown business district where people would go to engage in free speech. And so a shopping mall is going to act like the downtown business district, and it should assume the duties of the downtown business district, including hosting speech. The court decided that briefly and then reversed course about 4 years later. In 2017, the court decided a case called Packingham in North Carolina, which involved, can the state of North Carolina prohibit sex offenders from using social media? And the court said 9-0 no, but it split 5-4 on why. And the reason it split 5-4 was because Justice Kennedy, in what I like to call like one of the many cases in the canon of the unintended consequences of Justice Kennedy's rhetorical flourishes, where he called the internet the modern public square. And the concurrence in that case was uncomfortable with that phrase because it suggested that Kennedy was saying social media is like the mall or like the company-owned town, and therefore should have some First Amendment-like obligations. I still think on the whole, social media companies have a First Amendment right of editorial control to decide, because there are companies whose quintessential business is publishing speech, like the Miami Herald and Herald v. Tornillo, that the First Amendment protects their decision to say who should be published on the platform, who should not be published on the platform, and how those publications should be arranged in the individual time. But I'm not as confident as I once was that that's where the court's going to come. Does that answer your question?
We can take one more.
I have to pick between my two. So I'll go for one that's building off that. Let's imagine that SCOTUS grants cert in either one of these cases or another case in this circuit split, and they side with the fifth. They say these social media bills totally okay for states to do, give states more or less free rein. As I understand it, both of your positions on 230 is basically pro status quo, and I'm with you on that for if no other reason, just a Berkman minimalism thing. But if states step in, they're throwing off the status quo. How can Congress, what would Congress have to do then to reestablish the current status quo if laws like Texas's become more widespread?
So you could do something like what the Congress did in response to Employment Division v. Smith, right? So Employment Division v. Smith was a First Amendment religion case that overturned the preceding area of the law that allowed more exemptions for more religious exemptions to generally applicable laws. And Congress responded by passing RFRA, saying that thing that Congress overturned, we're making that federal statutory. And so that would, I think, help reinstate the Section 230 requirements with regard to federal statutes. It would have to find some source of constitutional authority to be able to preempt state law on those grounds, something like Section 520 members, something crazy like that. We see a shade of this in the net neutrality area, where the FCC repealed net neutrality laws, and so states started imposing net neutrality laws on their own. California is the most prominent. And so Congress is kind of trying to decide, should we preempt these state laws or not? And part of it, the answer is going to be, well, what effect are they gonna have on the way the internet operates? In the net neutrality context, it's not, it doesn't really seem to have much effect because most broadband providers were acting in a net neutral fashion voluntarily. And so we can't say you have to do this. It didn't lead to any real conflict. In the social media landscape, if Texas gets away with what it did, right, it could lead to a lot more conflict between states about what is and is not personal. And it's not just conservatives who are concerned about this. There are a number of liberals who are concerned about, for example, social media companies suppressing access to information about access to abortion providers, right? And so Elizabeth Warren wants to pass a federal law that prevents companies from suppressing or censoring that. Once we start down that path, it becomes a huge free-for-all to engage in exactly the type of conduct that, in my sense, is the person in this most restricted. I don't know if that answers your question.
Yeah, definitely.
Great, thank you so much, everyone, for coming, and thank you for taking time out of your schedules to come and talk to us. Before I let you go, we would like to invite you to our next event is on Monday, same room, so room 182 at 6 p.m. The title of that event is The Chevron Deference, the Major Questions Doctrine, and the Future of the Administrative State. Thank you.